A Supreme Court move is shaking the gun law world right now, and a lot of people are getting the story dangerously wrong. If you trust the hype instead of the facts, you could think you're legal to carry when you are absolutely not. Quick question before we continue. Are you subscribed? Because what I'm about to explain could help keep you from making a mistake that turns a normal day into a criminal case. Hit that button now. Here's what just happened. People online are calling this an emergency Supreme Court ruling that ends restrictive carry rules across America. That headline is explosive. It gets clicks. But here's the truth you need to hear. As of right now, the Supreme Court has not issued a final nationwide order that wipes out every restrictive carry law in America overnight. And that matters, because if you hear the court fixed it and stop paying attention, you could walk into the wrong place with your firearm and find out the hard way that your state still plans to prosecute. What is real is still a very big deal. The court has already changed carry law once with the Bruen decision. That case said states cannot force regular citizens to prove some special need just to carry in public. Then, after that, some states rewrote their laws fast, really fast. They started building new limits around carry permits, new sensitive places, new training rules, and in some states, a new rule that basically says private property is off limits unless the owner clearly says yes. Now, the Supreme Court is looking again at where the line is, and if the court goes the way many people expect, some of the toughest post-Bruen carry rules could be in serious trouble. Let me break this down for you in plain English. First, you need to understand the map. Before Bruen, states like New York could tell you, sure, you can apply for a carry permit, but first prove you have a special reason. That meant self-defense was not enough for regular people. The Supreme Court said no. The court said the Second Amendment protects carrying for self-defense outside the home. That was huge. But here's the crazy part. After losing that fight, some states did not just surrender, they changed tactics. Instead of saying, you can't get a permit unless you're special, they said, fine, you can get a permit, but good luck finding anywhere you can legally carry. That is where the real battle moved. New York became one of the biggest examples. The state passed a new law with a long list of places where carrying was banned. Schools, government buildings, certain entertainment places, and more. It also added training rules. It added more conditions. And one part really caught people's attention. In many situations, private property was treated like a no-carry zone unless the owner gave permission. Think about what that means in real life. You pull into a gas station, you stop at a small store, you grab food, you visit a friend's business, you go into a parking lot attached to private property. If the law assumes no carry unless clearly allowed, suddenly your permit starts feeling a lot smaller than you thought. Now, this is where it gets interesting. Gun owners challenged those rules in court. Some lower courts blocked parts of them. Then appeals courts stepped in. In an earlier New York fight, people asked the Supreme Court for emergency help. The court did not give them that emergency relief at that time. And this is the part most people miss. A refusal to step in right away is not the same thing as saying the law is constitutional forever. It can mean the court wants the lower courts to finish the case first. In fact, two justices made clear back then that people should not read too much into that temporary refusal. Translation: the Supreme Court was not blessing every one of those new carry restrictions. It was saying, not yet, keep litigating. And that brings us to the next big point. New York was not the only state pushing this strategy. Hawaii and California also put major restrictions on where permit holders could carry. One of the biggest fights involved a rule on private property open to the public. Picture a restaurant, a store, or a small shop. Under that kind of rule, even if you have a permit, carrying there could be a crime unless the owner gives clear permission. Most people think private property rules are simple. Their property, their rules. And yes, owners absolutely have rights. But the legal fight here is about who gets the default rule. Is the default, you may carry unless the owner says no? Or is the default, you may not carry unless the owner says yes? That one switch changes everything. If you're finding this helpful, imagine what you'll learn in my next video about the exact words that can protect you when police start asking questions about your gun. Subscribe so you don't miss it. Here's the part nobody's talking about enough. The real breaking development is not some magic emergency order that erased carry limits coast to coast. The real development is that the Supreme Court agreed to hear a major case out of Hawaii called Wolford versus Lopez. That case goes straight at one of the biggest post-Bruen tricks, making private property open to the public off-limits by default for licensed carry. The court heard argument, and a lot of legal watchers came away thinking several justices sounded skeptical of Hawaii's rule. That does not guarantee how the case will end. Never bet your freedom on oral argument vibes alone. But it does tell you this fight is alive, serious, and very likely to affect more than just Hawaii. Why does that matter to you if you do not live in Hawaii? Because the legal question reaches far beyond one island state. If the Supreme Court says a state cannot treat almost every business like a default gun-free zone unless the owner says yes, that logic could hit similar rules in other states too. It could weaken the whole strategy of replacing one unconstitutional carry barrier with 10 new ones. And that is why people are excited. Not because the job is finished, but because the next chapter could be massive. But wait, there's something even more important. Even if the court rules for gun owners in that case, that does not mean every sensitive place rule dies. That is one of the biggest mistakes people make. They hear one win and assume every restriction is gone. No, schools are still a different issue, courthouses are a different issue, government buildings can be different, places with strong historical limits may still survive. The fight is often about how far a state can stretch the idea of a sensitive place before it swallows your right entirely. So if somebody tells you, the court just made all carry restrictions illegal, that person is overselling it. And if you trust that oversell, you may be the one paying for it. Here's a hypothetical example to explain this. Imagine you have a valid permit. You're driving home from work. You stop at a grocery store on private property open to the public. There's no sign on the door, no metal detector, no employee says a word. You assume you're fine. But in a state with an express permission rule, the prosecutor may say you committed a crime the second you walked in with that firearm. That is why this case matters so much. It is not about abstract law school debate. It is about whether normal permit holders can figure out the rules before they are in handcuffs. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Let me give you the second thing you need to watch. The court is not just looking at where you can carry, it is also looking at how lower courts use history after Bruen. That sounds boring, but stay with me, because this part matters more than people think. After Bruen, courts were told to look at the text of the Second Amendment and the nation's historical tradition of gun regulation. Then the argument started. Which time period matters most? How similar does an old law have to be? Can a state use late laws from a very different era to justify modern restrictions? These sound like technical questions, but they decide real cases. If the court tightens that test, states may have a harder time defending broad carry bans dressed up as common sense. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who follow these updates before the news gets twisted into clickbait. Click subscribe. Third, let me explain what most people get wrong about emergency rulings. They hear the word emergency and think the Supreme Court slammed the brakes, changed the law, and issued a final answer. That is not usually how it works. An emergency request is often asking the court to pause or block something while the full case keeps moving. Sometimes the court says yes, sometimes no, and sometimes a no does not mean the law wins forever. It just means the court is waiting for a better moment. That is exactly why you need to separate internet drama from legal reality. Right now, the honest way to say this is simple. The Supreme Court has already reshaped carry rights with Bruen. It previously refused to short-circuit at least one New York fight on an emergency basis, and now it is reviewing another major post-Bruen carry restriction that could reshape the law again. This is the part that shocked me. Even after Bruen, a lot of states acted like they could comply on paper while resisting in practice. In other words, they stopped asking, can we deny the permit? And started asking, can we make the permit almost useless? That is why these new cases matter. They test whether the right to carry means a real right or just a right that disappears the moment you step onto private property, enter a business district, or pass through half the places people go every day. So what should you do right now? First, do not assume a headline changed your state law today. Check what is actually enforceable where you live. Second, do not assume your permit gives you blanket protection on private property. In some places, signs matter. In some places, consent matters. In some places, specific bans still apply even if no sign is posted. Third, do not treat social media as your lawyer. I know that sounds harsh, but some of the loudest voices online are giving people confidence they have not earned. Confidence is great. False confidence is dangerous. Imagine you get pulled over tomorrow. The officer asks where you're headed. You mention you just left a restaurant or a store. If your state still treats that place as off limits, the whole conversation changes. Now think about the stress of that moment. You thought you were following the Constitution. You thought one Supreme Court headline protected you, but the local law on the books had not changed yet. That gap between national hype and local enforcement is where people get burned. Fourth, pay attention to what kind of place you are entering. A business open to the public is not always treated the same as public property. Fifth, watch your state legislature, not just the Supreme Court. When courts limit one rule, lawmakers often try a new version. Sixth, if the court rules in Wolford the way many expect, do not assume the decision applies instantly and perfectly everywhere. There may be more lawsuits, there may be more confusion, there may be officials who keep enforcing until a lower court tells them to stop. That is frustrating, but it is real life. Laws change fast, like really fast. Subscribe now so you're never caught off guard when the next ruling drops and everybody online starts shouting before they've even read it. So here's the bottom line. The Supreme Court has not issued a magic nationwide emergency order that suddenly wipes out every restrictive carry rule in America. But the court is actively dealing with the next huge carry fight, and that fight could seriously weaken one of the most aggressive anti-carry strategies used after Bruen. If you remember one thing from this video, remember this. Do not carry on hope, headlines, or rumors. Carry on facts, on current state law, and on a clear understanding of what the courts have actually done. If you want real updates without the panic, the spin, or the fake victory laps, subscribe right now and stay with this channel. And final simple disclaimer, this video is for education only, not personal legal advice. Your state rules can be different, and if your freedom is on the line, talk to a qualified attorney before you act.